Good evening, everyone. Good evening, Attorney General. Thank you very much for inviting us to speak this evening, and we look forward to engaging with you on these matters in the future. I wanted to speak about this topic from a practitioner's perspective. I recently remigrated to Guyana in 2014, and 90% of our client base are foreign investors doing business in Guyana. And the number one question we're asked at every threshold meeting, well, how safe is it? How secure is it? And of course, those questions have intensified in light of recent events from 2018 to now. And we've often had to write opinions as to the enforceability of contractual arrangements. And of course, what would happen in the event that the political climate made it difficult to give rise to investor confidence. And I'm just going to address you briefly on that aspect of the rule of law in Guyana. And the conclusion is, we're very pleased to conclude that Guyana, despite what may attract the public headlines, has one of the most robust legal and statutory systems in the Caribbean and one of the most robust court structures in the Caribbean where investor rights are adequately secured. So much so that during the passage of the no confidence motion and throughout the electoral foray, we represented a recently made public transaction, Elliott Management, and the investment of an oil block here. Despite the ongoings, we had sufficient legal security to advise our clients that it is possible to invest with certainty of recovery and certainty, at the very least, to compel the government and all other parties to adhere and respect legal rights. Just a brief overview of Guyana for those of you that don't know, and forgive me if you do. Guyana, just like the rest of the Caribbean, is based on English common law principles and generally English statutes, except property matters and company matters. Our judiciary in Guyana, as the Attorney General alluded to, has actually become one of the most efficient judiciaries in the Caribbean. And I say so with great pride and amazement. And I have seen a marked change from when I returned here in September 2014 to today, and especially with oversight from the Caribbean Court of Justice, which is our highest appellate court. The courts themselves, the standards are incredibly high when compared to our sister countries, certainly meeting more advanced economies in the Caribbean. And with the speed of resolution, to the extent that there has been limited exposure to complex legal disputes, the availability of the appellate process, coupled with the oversight of the Caribbean Court of Justice, gives great investor confidence. Where things may go awry, they can be quickly straightened out. Cases in our courts of first instance typically take between 3 to 12 months to be resolved on average currently, except of course if there are very significant commercial disputes which involve mountains of evidence and many witnesses and things of that nature. But still, it doesn't take much longer. Courts don't adjourn for long periods of time. Trials go on from day to day, from 9 to 5. And we have very strong and robust commercial court judges. Appeals taking on average about 3 years to be heard, which is standard throughout the developed world. And to get to the final tier could take between 3 and 8 months for a final decision. So from beginning to end, there is a comprehensive timeline of 4 to 5 years for a resolution of a matter, which is not shoddy compared to New York, where I was for 13 years, or London, or Barbados, or Trinidad. There are two dichotomies of law here, private law and public law. And from the public law standpoint, to put it from a layman's perspective, often the questions asked are, well, what protection do tenderers have? Small countries like ours tend to have a poor reputation and a perception that because we are so small, tendering, for example, is not done in a manner which is fair, transparent, and equal to persons that are not familiar with the jurisdiction. And we, again, are pleased to say that the rule of law steps in Guyana quite promptly to quash decisions by tender bodies, which may make decisions which may be unfair or don't follow doesn't follow the law. Guyana actually has, under the auspices of our Attorney General, one of the most advanced procurement legislations in the Caribbean, and it's something that's taken quite seriously. And if for some reason there is some inadvertence on the side of the public body, the courts are quick to step in to correct what is wrong. And our jurisprudence is replete with cases from the time the Act came into force to present, where persons have gotten a speedy resolution to matters. From a private law perspective, our law of contract is governed by English law. The principles are imported wholesale here. Our company laws mirror the laws of the Canadian Business Corporation laws, and the jurisprudence is, just as in Canada, a mix between English and Canadian jurisprudence. Security interests, depending on their nature, follow international principles. So, for example, just this evening, we represented a very large aircraft retailer who was quite happy to secure a $10 million transaction using Guyana law and using Guyana security mechanisms. Again, it's a testament to how strong our system is, despite what may be the background noise in the public domain concerning whatever electoral issues we have. Once you get down to the detail, Guyana has a very, very robust legal architecture. From a risk perspective, foreign judgments and arbitral awards are routinely recognized and enforced in Guyana, despite the fact that we do have a very old arbitration act. There are many instances where very sophisticated cases are decided in other jurisdictions. Those judgments are recognized immediately by the courts. By way of an example, just about 12 months ago, we had a London Court of International Arbitration arbitral award on a very complex mining issue decided in London. We had to bring it to Guyana to enforce that judgment here. And the parties here attempted to defeat that arbitral award by saying that either the arbitral award was illegally obtained or it offended the laws of Guyana. And the judges in multiple instances, both in the first instance court and the appellate court, recognized the principles governing comity, the principles governing respect for an arbitral award. And it gives us great comfort, certainly gives, as citizens and residents of Guyana, great comfort in saying that investors can come here and invest freely with great certainty. To date, we have seen no situation, absolutely no situation, where a private party or the state has managed to abscond and ignore its legal rights or their respective legal rights and not be made to adhere to what was agreed. And one of the first instances of one such example occurred in 1993. This is in our modern electoral situation where we had our first free and fair election, arguably in 1992. One of Guyana's state companies, Guymine, the Guyana Mining Company, which is responsible for bauxite and was one of the most successful bauxite mining operations in the world, went bankrupt, insolvent in essence, which resulted in many creditors being owed substantial sums, which the government simply was unable to repay. And instead of engaging in matters which could have caused investors great strife, the government opted to respect the investors' interests, and whilst being unable to immediately repay, converted that debt into 12-year bonds at a very favorable rate of 6% tax-free, and eventually paid interest promptly over the 12-year period and repaid those bonds. Even when there was a change in political outlook, and the government then took a more aggressive stance in causing investors to litigate to enforce their rights. And there's one particular example I wanted to bring to the audience's attention involving a Trinidadian company called Dipcon. They got about a $2 million judgment against the Attorney General. The government at that time took a hard negotiation stance and simply said, after getting the judgment and exhausting the appellate process, being served with the judgment, that we are not going to pay this judgment. The courts here quite willingly issued an order threatening to commit the Minister of Finance to prison. Now, that just goes to show that despite the backdrop of what's happening in the public domain, the courts here are not afraid, and they do respect the rule of law, and something I think is very significant for us, all of us here in this forum, to understand and appreciate. Guyana's doors are open for business. And the initiatives that we have been fortunately privy to, that the Attorney General's chambers are now undertaking, will only further strengthen and enhance what's already here. And some of our laws are old, and some of our laws may have a different spin to them as compared to more modern laws, but ultimately the effect is the same. And we say so with great confidence and great pride, that we believe that Guyana is really a safe haven for investors. So on that brief note, I know the Attorney General's Act was a very hard one to follow. We simply wanted to give an overview of really the implementation of the rule of law in Guyana, and to assure all persons who are listening here today that Guyana, and especially under the stewardship of our Attorney General now, is well poised to become a model state in a first world sense. Thank you very much, ladies and gentlemen.